Welcome to Walshs and Hillhouse Legal Partners, starting out in private practice, financial and legal foundations. This afternoon, we will discuss the key financial and legal considerations when starting out in private practice or transitioning to private practice. We would like to thank the RACS attendees who are tuning in. Historically, we've had a great relationship with RACS and continue to be the chief education provider. If you do have any questions during the presentation, please use the Q&A function and we will answer your questions at the end. For those of you who haven't heard about us, being Walshs, we are a business that's been around for about 32 years. We have around 3,000 doctors and 600 of those in private practice who entrust us with their taxation, financial planning and mortgage broking services. We are a firm that prides ourselves on managing the progression of our clients' assets from interns through to private practice and business ownership. Our goal is to holistically provide sound, timely advice while growing, maintaining and protecting your wealth. Today we'll discuss in terms of the financial side, which structure is best for you, starting out in private practice, the considerations, transitioning to private practice, the ATO compliance considerations, how you pay your tax, a tax comparison between a suburban accountant and a medico-specific accountant, and then service entities and buying into a practice. My name's Ben Knoblanche. I'm a client manager at Walshs and also the business advisory team leader. And I'll be joined by Craig Hong later in the piece, who's a director of Hillhouse Legal Partners in the commercial space. So a disclaimer, everything that we're about to present to you tonight is general in nature. It does not constitute specific financial advice. Therefore, you cannot use this information or rely upon this information to make financial decisions. We suggest you seek advice from your advisor or professional if doing so. So when starting out in private practice, there's a lot of considerations, especially if you are moving into practice ownership. But this afternoon, we're mainly going to focus on, the accounting software, financing, structure, registrations, and legal side of things. The first, hurdle to surpass is which structure you should trade as a practicing doctor once you transition from working for, salary and wages as a training doctor through to a consultant. And those three main structures are a company, trust, and sole trader. With each of those structures, there's three attributes which will determine which structure is correct for you. So they are the tax efficiency, the asset protection mechanisms, and the cost of that structure. Generally, as an ABN sole trader, the cost to set up that structure is relatively insignificant in terms of a ABN and GST registration, which I'll touch on a bit later. And then the ongoing cost is, again, quite low in terms of there's 4 business activity statements that are required to be prepared and your personal tax return. As soon as you move to a company or trust structure, the cost to set that structure up is sort of $2,000 to $3,000 straight away. So that's a sunk cost. You don't get that back. And then in addition to that, the ongoing compliance cost essentially doubles each year, because what needs to happen is that company or trust will require 4 business activity statements, a set of financial statements, and a tax return every year, in addition to your personal tax return. So therefore, there's 2 entities that the compliance work is being prepared for. That's why the cost essentially doubles. In terms of asset protection, generally as a sole trader, it's quite low. If something does happen and someone makes a claim against you, any assets you hold in your personal name are then subject to that action. Generally, as you move to a company or trust structure, the asset protection mechanisms increase because what you generally find is if any action's taken against that company or trust, the action's only limited to the assets of that company or trust. Now, being a practicing doctor with a provider number, you're in a pretty peculiar situation, whereas even if you trade as a company or trust, you're still billing patients through that provider number. Therefore, if there was any action taken against you, you are still personally liable and any assets in your name are still open to that action. with our client base of over 600 doctors in private practice, we see the best form of asset protection as being good indemnity insurance. And it's really important that, if you are, moving towards private practice, whether it be a day a week, 2 days a week, or jumping into it full time, that your income levels are generally going to increase. And therefore, it's really important to let your indemnity insurer know of what those increased income levels look like. As long as there's no sex, drugs, alcohol, or malpractice involved, we've seen with our client base that indemnity insurance kicks in, and that is your best form of asset protection. And the last one is the tax efficiency of the structures. So generally, if you're earning over $190,000 as an ABN sole trader, you're being taxed at 47% in the dollar. While there's not much we can do about that tax rate per se, there are certainly strategic deductions and tax planning measures that we can implement that reduce the tax you pay. Generally, a company's tax rate is 25%. So if they earn, say, $100,000 for a financial year, they should generally pay $25,000 in tax. And a trust works in a way, in a bit different. It really depends who the beneficiary is. So income is earned into the trust and it has to be distributed to beneficiaries. So it really matters what other income that beneficiary has to determine the overall tax efficiency of that trust. Now, being a practicing doctor with a provider number, you are going to be caught under what's called PSI, or personal services income, which is a ruling handed down by the ATO, which essentially stipulates that as long as you're a practicing doctor, you are personally exerting yourself every day to see patients and earn income. If you stop working, income stops being derived. Therefore, all of that income needs to be taxed in your name, which essentially means that even if you operate as a company, you don't have access to that concessional tax rate of 25%. All of that profit at the end of the year is pulled out of the company, so there's nil profit, and it's attributed to you, and you pay tax at your marginal tax rates. The same thing happens with the trust, is all of that income would have to be distributed to you, therefore taxed at your marginal tax rates. So effectively, throughout the three structures, sole trader, company, and trust, the tax efficiency or the tax outcome is the same. The asset protection mechanisms are the same. But with a sole trader, the cost is the lowest, and that's why we recommend a sole trader structure. Next, we look at the compliance considerations. So PSI, personal services income, we've been through. The next thing you'll need will be an ABN, an Australian business number. And if you foresee that you will turn over more than $75,000 since you start private practice in the following 12 months, you'll need to register for GST, Goods and Services Tax. Now, with a GST registration becomes an additional compliance burden imposed from the ATO, and that is the lodgement of a BAS, or Business Activity Statement, every quarter. So essentially think about them as mini tax returns. And what the ATO want to know is your GST on income, GST on expenses, and your actual income. So income, relatively easy. We can get that from a receipted billings report. GST on income. So there'd be very little to no GST you're paying to the ATO, as medical services and supplies are GST free in Australia. The only time there'd be GST on the service you're providing is if you're doing medico-legal reports or some sort of cosmetic surgery, some private assisting. The silver lining is any GST on your expenses, you get to claim back. So your biggest expense will be service fees, depending on what specialty you're in. They range from, say, 30% to upwards of 60 or 80% if you're sort of in that radiology space. But generally for most surgeons, we see they're around 30 to 40%. Any GST on that, you get to claim back. It's really important when you make that move into private practice that you also understand who is doing your billing and what your service agreement or contract looks like with the practice. So that service fee that you're paying of, say, 30 to 40%, does that include a room when you need it, the admin staff or the practice manager receiving all your billings? Is that then paid into your own bank account? Do they withhold all of your billings and pay you the net amount of that 30 or 40% service fee? it's really important to get these structures right in the first instance and understand how you're actually going to receive your billings. What I would say is it's imperative that when you do start out in private practice, that you set up your own business bank account. And effectively what that bank account will be used to do is collect all of your billings, whether it be net of the service fee or your billings. And then that business bank account is then used to pay all business expenses. So that will be service fees, indemnity insurance, college fees, basically any expense you have in administering your private practice, then get paid out of that business bank account. Now, if you're doing, say, a day a week in private practice and the rest you're still working for, the government body, what I'd suggest is all expenses get paid out of that business bank account. And what we do with that business bank account is set up a Xero file for you, Xero, which is a worldwide accounting software. And essentially what it will do is duplicate all those statement lines in the Xero file. And then we use that to prepare your business activity statement every quarter and your tax return every year. On the back of that, it's really prudent to look at some tax planning strategies. So there are ways of sort of restructuring a bit of debt. So you may have debt on your main residence, which is non-deductible debt. So there's certain avenues where that can be restructured to pay for business expenses that you could then convert that to tax deductible debt and claim an interest for, or a deduction for some of the interest on that debt. Superannuation is a really big one, especially if you are moving into private practice full time. It's really important to still consider your superannuation because it's a great investment vehicle and a nest egg. Essentially, if your tax rate is 47%, your marginal tax rate, anything you contribute to super, you get a deduction of 47% and it's taxed at 15% when it goes into the super fund. So basically anything you put into there up to the concessional limit of say $30,000, you get an arbitrary tax advantage of 32% straight away. In addition to that, there is the carry forward concessional contribution. So if you haven't maximised that $27,500 or $30,000 limit in the previous 5 years, you could basically carry that forward and potentially make a lump sum contribution in this financial year. In addition to that, because you're now running your own business, you're entitled to employ someone to help you administer your private practice. So, you know, if potentially there's someone in your family group that isn't working or not earning other income, you could employ them to help you administer your business. The first $18,200 of their taxable income is tax-free. You'll get the deduction of 47%. In addition to that, it's quite a stringent process. So we will have to set up things like work cover, super stream, pay the super every quarter, get a role description in place as well. Next, we move on, how do I pay my tax? So once you're in private practice, essentially you're earning this untaxed income where you're getting 100% of your income and no one's withholding any of that tax. So there will be a tax bill, but you will be on a bit of a tax honeymoon for a while. So if we look at this example here, let's say you started private practice in January, February 2025. You're going to earn untaxed income from, say, January 2025 to June 2025 for that financial year. If you lodge your tax return through a registered tax agent like Walshs, that tax return isn't due for lodgement until the 15th of May 2026. Now, there's two reasons why we would delay the lodgement of that tax return. Number one is that, firstly, if you lodge that tax return any sooner, say if you lodge it in October, you would have to pay the ATO straight away. That money is much better invested elsewhere for that period till May 2026. The second one is, as soon as you lodge your tax return with the ATO, they're going to understand that you're earning untaxed income. And they're not going to wait another year to get, say if your tax liability, and this is an absolute example, was $40,000. They're not going to wait another 12 months to get $40,000. So in each of your BASs, you're going to enter the pay-as-you-go installment system. If your tax return is lodged in October 2025, you're going to have to pay $40,000 then. You're going to have to pay $10,000 on the December BAS, $10,000 on the March 26 BAS, and $10,000 on the June 26 BAS. By delaying the lodgement of your tax return to May 2026, you pay $40,000 in May and $10,000 in June 2026 on that business activity statement. This is just a little tax comparison between, let's say you still had, Queensland Health or whatever government entity it might be, income of 180,000, private practice income of 200,000, and you had standard deductions of indemnity insurance, rack subscriptions, whatever they might be, of roughly $12,000. Your overall tax payable is roughly $93,000. Let's say you did the same thing. You employed your spouse for $25,000, contributed to their super for $27,500, and then had a $3,000 deduction from that debt management system. You pay about $66,000 in tax. So there's a saving there of roughly $25,000, $26,000 on tax just by using a medico-specific accountant that understands the industry fully. And that tax saving will compound year on year. Service entities, this is sort of geared towards when you do enter practice ownership, but essentially what it's showing you is 3 different doctors at 3 different, stages in their career. Dr. Low might be, like I said, a day a week or maybe 2 days a week in private practice. Dr. Medium might be 3 or 4 days. And Dr. High might be a very senior consultant doing 4 or 5 days with a much higher billing level. So all this is showing is that there are certainly avenues in that practice when you do become a practice owner to pay out profit from that practice in proportions that each of the owners have paid service fees in or contributed to the practice profit. And lastly, look at buying into a practice. So practice ownership certainly isn't for everyone. And the first thing I would encourage is both financial and legal due diligence to make sure that what you're buying is what is being advertised. Craig and I do a lot of this work together, and on a few occasions, it certainly isn't what it's all being cracked up to be, and the buyer walks away. But it's really important you go through that due diligence process and fully understand the practice and what practice ownership means for you. You're going to end up being HR, the practice manager in some form or another. You're now responsible for a considerable increase in compliance information. And then probably on that, or the big part of that due diligence process is working through what the structuring looks like. How do we structure the debt if we need to buy the practice? Are we buying rooms as well, potentially in a self-managed super fund or a unit trust? What does that look like? And I guess the overall asset protection strategies and review of legal documents in terms of leases, employee agreements, and certainly shareholder agreements. That was all I had for the Walshs section. I'll now pass over to Craig from Hillhouse, who will talk about the legal foundations.
So hopefully everyone can see that. And thanks, Ben. So I'm Craig Hong. I'm the Corporate and Commercial Director of Hillhouse Legal Partners. We are lawyers in the business of helping doctors run the business of medical practice. So we're not doing your, medical negligence claims, things like that. We are helping you out with, making and keeping as much of your money as you possibly can in private practice. So we're just going to run through very quickly, I suppose, some of the likely things you're going to come across, both starting out and then as you do venture into potentially joining a practice or buying a practice or starting your own with colleagues. So we're just going to run through some of those things and sort of give you, a taste of the things you're likely to encounter. So that's me. I've been doing this for about 20 years. Started out, my first medical practice was neuros, but now we cover basically every specialty under the sun. A lot of GPs and a lot of radiology and things like that. And so, look, as Ben was just talking about, look, when you are selecting consultants, it really is important that you do choose medical specialists. Ben gave you some examples there of how it plays out, and that story is pretty true across all sorts of advice. You know, Ben will be able to tell you why a cardiologist can justify a different service fee than maybe an anaesthetist, and those differences can be quite substantial. And if you get it wrong, you know, you could have a big problem with the ATO on an audit. In legal, you know, in leases, you need very specific clauses in your leases about how you're going to run. If you're running a service entity, you need to be able to license to um, other doctors that work in your practice without having to go and getting the landlord's permission every time. Otherwise, you could be costing yourself, you know, $10,000, $15,000 a year on top in extra legal fees from the landlord that you wouldn't otherwise pay. IT, they'll be familiar with, you know, your practice management systems and imaging and things like that. So, and that's across, you know, all sorts of things. And there are lots of specialist medical providers out there. So make sure you do use one, as opposed to, you know, just suburban accountant, a mate that you went to uni with that might work in a field but might not be a medical specialist. Even worse, trying to do it yourself. They say anyone that does their own legal work has a fool for a client. And that goes for me too. I never do my own legal work. When I'm buying a house, doing my wills, whatever, I get someone else to do that for me, because you're not objective, and you may only be specialized in certain things. So only stick to your knitting. Don't try and do any of this stuff for yourself. Particularly for doctors, it's just not financially a good move, because you can make more money as a surgeon than you can as a part-time lawyer or part-time accountant. So make sure you're just getting that advice to save yourself time and money, and you're going to get much better quality advice. So when we're setting up things, so solo, look, everyone's going to be solo, as Ben ran through before. But then I guess the next things that are likely to happen as you evolve in your career is you might establish a group of colleagues, or you might buy into an established group. If you're starting out as a sole trader, you will probably be just joining a group by way of a service agreement. So you won't be buying into that group, but you will be signing a service agreement where they will be providing you some services. When I say keep it simple, we don't want to see structure charts like this. If you have a structure chart like that, Ben will be getting very rich off your annual compliance as you deal with all those heaps of entities. But as you introduce all of those entities, you're also going to introduce the potential for mischief and mistakes. And if you look up in the top left-hand corner of that chart, that's the structure chart for Enron. And they obviously got up to plenty of mischief, blacking out California and costing taxpayers over there millions, billions of dollars. So yeah, you really just want that structure that achieves your goals, but doesn't do anything further. So we don't want to overcomplicate things. We want to just keep things as simple and clean as they possibly can be. So solo, we're just working out what is my trading entity. As Ben ran through, there's really no benefit to anything other than a sole trader structure for your actual medical practice yourselves. But then you're probably going to either need a service entity that you set up yourself for some tax effectiveness, or you will be getting services from another service provider. So that's an established group. And then you're going to have to think about, you know, where are you going to do this? Are you going to be out of a hospital, get out of a specialist center? Is it something that you can do some consulting completely remotely? You know, you've just got to work through those issues. And then if you're talking about premises, are you going to license those premises, lease them, or are you going to buy premises, which might happen in your super fund? And then you lease it to your own business. And then how are you going to get help? Are you going to get staff, or are you going to use something like a virtual medical practice, which is out there, which is, I guess, offers some flexibility, but has a bit more cost associated. So if you are looking to establish a group, we're going to be asking questions: how are we going to share the costs, and how are we going to share the profits? And what are we going to do if people want to leave? What are we going to do if people want to join? And what are we going to do if something unforeseen happens? So if someone gets sick, gets hit by a bus, those type of things. And so usually that will be controlled by way of a shareholders agreement between all of you that basically answers those questions, and then might have some extra questions about how we are going to make decisions if we're not covering off on those particular points. If we're buying into a group, as Ben said, we'll be talking about due diligence here. So what we're going to do is have a look at what the structure is and see, is this appropriate? Is there any opportunity to potentially change things or make improvements? Because obviously when you've got movement in and out, that's kind of a good time to think about those things, because the existing owners will also have movement. So they just need to think about if there's opportunities there for them to do a restructure. And that does happen sometimes, that it does become a good, I guess, inflection point for the existing owners to look at their own structure. And then what we're going to do is look at all of the documents, look at the figures, and see whether what you're being told is the story actually happens in reality. So we're really just, I guess, fact checking that the story you're being sold and the opportunity that you're being sold actually lines up with what the documents say, so that you really are getting what you pay for. And then we're just going to have a look at what the transaction costs might be to do that entry. So that, for the people selling, they will have some capital gains tax to think about. But for you as a buyer, depending on the structure, you might have some stamp duty. And so that will really depend on the structure that you're buying into. If you're buying into a company, generally no stamp duty. If you're buying into a unit trust, there will be stamp duty. If you're buying into a partnership or a business, there will be stamp duty. So it really kind of depends on what you're doing and what's happening, as to what the transaction costs are likely to be. So the documentation that you're likely to come across is shareholders agreements, unit holders agreements, partnership agreements, depending on what it is you are buying into or establishing. The service agreement, which almost everyone will come across, because you're either going to be doing those yourself in a practice, or you're going to be entering a practice where these things already exist. Employment agreements for staff, and then something around the property. And so that'll be likely a lease, license, and incentives. Now, even if you go out and buy that property, the lease is going to be a live issue, because your super fund is likely to be owner, or a separate property trust, and the business entities are still going to need to lease that premises. And it's really important for compliance that those leases are in place. So the shareholders agreement, look, it just covers off the interactions between the owners, as I was talking about before. So usually the base documents that you get when you set one of these, whether it's a company or a trust, there'll be a constitution or a trust deed. But usually those things are basically off the shelf. So you hear the term a shelf company. What that basically means is that you will get a document that is very generic, and it'll have all of the, I guess, basics of how a company is run, but it won't have any specifics particular to your situation. So what the shareholders or unit holders or partnership agreement is going to do is really tell the story of how you want to operate things amongst yourselves. And so we're just going to cover off on key issues like who has control of this thing, who's a director, and what sort of vote do they get at a board meeting. The most common ways that is done is usually everyone gets one vote, or the other alternative is that you might vote in accordance with how many shares you ultimately control. So if you have a shareholder that owns 75% of the shares, they may say, I want to have a bigger vote as a director because I represent 75% of the ultimate shareholding here. So that's just an issue you would have to talk out and resolve how you're going to deal with those things. Decisions themselves will usually be by ordinary majority, special majority, or unanimous. So usually a special majority is going to be 75% or more in favour. Unanimous is obviously everyone in favour. Ordinary majority is just, more than 50%. Then we're going to talk about how we're going to share profits. And the most common ways to do that is we do it equally. So if we all own 20%, we all take out 20%, or we have some sort of variable profit sharing mechanism. So before, when Ben was talking about Dr. High, Dr. Medium, Dr. Low, so in that circumstance, if we have an equal profit share, they would all take out a third. If we have a variable profit share, Dr. High is going to be taking out a lot more profit than Dr. Low, because it's kind of a get out what you put in profit sharing mechanism. If we have to borrow any money from the shareholders, what are the terms on how we pay it back? Is it just going to be a case of we pay it back when we're able to do so, or is the company going to have some onus to pay it back within a certain time frame, and are we going to charge interest and things like that? Entry, what are the rules to bring someone in? So will we be talking about everyone has to agree to someone coming in, or is it going to be one of these special majority or ordinary majority decisions? Do they have to hit certain thresholds before they're even offered that entry in the first place? And then we talk about exit. So usually voluntary exit is if someone wants to retire, someone wants to go and do something else, they're moving, whatever. Or there's these involuntary exits. So that's if there's a breach, you're no longer registered as a doctor, or if you've, brought the practice into disrepute, or sometimes people even just put in a mechanism for if the majority or 75% or more just want someone to go simply because of personality differences. So, there can be mechanisms put in around that. And then we cover off on things like death and TBD, what's going to happen there. And obviously with all of those entry and exit events, we're going to have to work out what the price is. So usually there'll be some sort of valuation methodology put in place. And so usually the most common ways to do that will be either a formula. So we'll take the profits from, say, the last 3 years and run some sort of multiplier on that, or we would alternatively get some mechanism where we just get whether it's the practice's accountant or someone else to actually just perform a valuation, either by a set of rules, or just we leave it kind of to their judgment and expertise. And people have different views on that, and usually you would talk through I guess a preferred mechanism. So with these things, look, it's really important that just everyone has to be on the page from the start, particularly on that profit sharing. Look, if some people have the view that we're all in this together, and if everyone's all working full time in the practice, that can work very well. But sometimes if there is going to be a big differentiation between how much people are working, that variable profit sharing mechanism can be better. So it really is just important that everyone understands right from the get-go what the plan is. I'd be wary of unanimous decisions, because at the start, when everyone's all getting along, everyone thinks they're all going to see eye to eye. But down the track, if there is, I guess, some discord, sometimes you might have 9 out of 10 wanting to do something and the 1 out of 10 doesn't want to do it. And if you've got unanimous decisions, suddenly the 1 out of 10 effectively has a veto power over everyone else. So unanimous decisions is a very powerful tool, but it's something that's got to be used sparingly. And I guess in terms of the biggest of the big decisions only. Sometimes with events for death and TPD, if the practice has borrowed a lot of money or there's really significant value in the practices, sometimes we talk about going out and getting some insurance so that there's a pot of money available to pay for either to clear some debt or to pay out an interest if someone does die unexpectedly or is TPD unexpectedly. And that's, you're just going to have to work through, I guess, what are the premiums versus the benefits you're going to get. So and that is also going to just really depend on the practice and what the value is. And then we'll talk through those options for the valuation mechanisms, and usually that will happen in conjunction with your accountants because they'll have a view on the best way to, I guess, value the practice based on the type of practice it is from the start. Tips and tricks, always a joint meeting with the accountants and the lawyers. Really important to get everyone kind of singing from the same hymn sheet. What you don't want to do is have a meeting with one, go to the other, and then they have a totally different view on things. So it's really important you all sit down and nut it out together. We don't try and cover off on everything. I really do just cover off on those key issues that I talked about, because if we try to cover off on every possible scenario and every possible decision tree, what happens is you just start this document and never finish it because it just gets bigger and bigger and more complicated and the decision trees grow and people run out of time and, I guess, impetus to get this done. So, a simple and concise signed agreement is much better than an unsigned draft that covers off on lots of stuff. And it really is just really important to talk through everyone's expectations and get on the same page. And honestly, the people that go through that process properly are never the ones that end up in the disputes. It's always the people that either just say to us, can you just give us one the same as everyone else has and ask for a precedent effectively, or the people that don't do it at all that end up in trouble because what they haven't done is actually sit down and talk and make sure that they are all aligned before they get into business together. They just think they're aligned and they get a document that is pretty generic, and then when they find out that they aren't aligned, it's when they have problems. So the service agreements, I'm sure people have seen all sorts of things in the news about payroll tax. So service agreements are simply where the practice itself provides services to each of the doctors. And so the reason practices are set up like this is, as Ben talked about, most of your income is going to be personal services income, which generally is fairly tax ineffective. The one thing that doctors can do is that they can make a little bit of profit in this service entity that can potentially be distributed a bit more broadly. So usually what will happen is the service entity will be owned by family trusts belonging to doctors, and the profit that flows into that service entity can be shared through the family trust. So it can be distributed to others, subject to a few little quirks and rules, but there is some tax effectiveness available there. Now, that's not to say you can go and charge a 95% service fee and just push all the money through this service entity, but if it's in line with the sort of guidelines for your particular specialty, you can push some through. So we're getting some tax effectiveness, and we are also then covering off on payroll tax, because I guess that type of arrangement is something that is subject to payroll tax if you get it wrong. So that's why I guess one of the areas where the specialty lawyer is going to come into their own, because if you get that wrong, you really are potentially looking at a payroll tax bill on the earnings of all of the doctors, which can be very substantial. So, really important that is done properly. Employment agreements. Look, anyone that has worked in employment or has been in a workplace, even in hospitals, you'll know how stringent employment law can be. Once you're an employer yourself, it becomes even more pressing that you get this stuff done properly. So you're going to need employment agreements, you're going to need policies and procedures, and you're going to need to, I guess, apply those policies and procedures and employment agreements correctly. Now, this stuff generally, the actual establishment and getting this stuff done, and it's not that difficult if you go and see a lawyer and work through it properly. But it is something that if you don't systemize and get it done right, you can get yourself into all sorts of problems. Look, the other difficulty is that if you do ever find yourself in Fair Work Commission, you have unfair dismissal complaints, things like that. It's really kind of stacked against you as an employer if you haven't done these things properly, have the policies, and have a paper trail of how you've dealt with these things properly. So it's just really a case of, systems, policies, procedures, and paper that keep you safe on these fronts. And then look, there's lots of things that we can cover off onto in those documents, and there's just a bit of a list there on the slides. So, leave, termination, confidentiality and IP, non-competes, etc. Now, non-competes and non-solicitation. Non-competes can be difficult, but we can sort of tell you where the bounds are on those things. Even more difficult with doctors, because there's really good public policy reasons about why restraints can be very difficult for doctors, and you can only really get them in very specific circumstances. So if that is something you are looking at, or if you are offered one of these documents and it does, so if you're not starting a practice yourself, but you're just going into a practice and you have a service agreement put in front of you and it has restraints in it, it's something you really need to get some advice on, because it can really hamper your future plans. And it's generally something you can push pretty easily to get out of the document once you explain why it's no good. Now, these are also difficult to enforce, but just because they're difficult to enforce doesn't mean that someone's not going to try and you're not going to get a nasty letter from a lawyer. So if we can avoid that, we would rather do so. So if you do see a service agreement and you have those, make sure you get some advice. Leases. Look, I am a bit conscious of time. Everyone probably knows what a lease is. Key issues with leases is just, I guess, really when you go and see the real estate agent and you're negotiating this thing, make sure you get some advice right then and there at the term sheet start, because they're going to have all sorts of things. It's going to have rent reviews, security, fit out incentives, a make good. So what you have to do when you leave, sometimes you get to just clean the place and walk out. Sometimes you have to basically send it back to an empty shell, which can be very expensive. Sometimes there'll be personal guarantees, which make you personally liable if the practice itself doesn't pay the rent. Options for renewal, so whether you have the ability to stay for longer if you want to do so. You might want to ask for exclusivity of use, all sorts of things. So really is important with leasing that if you are being offered premises, you make sure you get advice really before you sign that term sheet, because once things are signed on the term sheet, even though it says the term sheet might be non-binding, they tend to be sticky and you find it very hard to negotiate out of those things. So yeah, look, you really need to engage a lawyer right at the start. You can also, there are property companies that do help in negotiation. So there are agents and things that will act for the tenant and can help you out on the commercial issues. Always ask for rent frees and incentives and things. The face price isn't, I guess, the end of the story. You know, landlords really want doctors in their tenancies, so they are willing to throw some pretty hefty incentives at you to get you in there, because generally you are great tenants, so they want you in there. And then you just have to do a bit of due diligence, I guess, as well about the premises. If you have particular plans in mind, make sure you run those past your lawyer, just to make sure that it all kind of checks out. IP and privacy, look, these are things that you're just going to have to grapple with. So trademarks, you know, privacy and data protection, cybersecurity, domain names and social media. And look, with that, even if you don't know exactly what you're going to do, what I would suggest is, if you do have a practice name that you're thinking about, just go and put your foot on them so that you've got it if and when you decide to take those steps onto those platforms. And ownership of IP, which will be covered in each of your documents. And then look, the last thing, and I guess this probably applies, I guess, whether you've made the leap to private practice, whether you're making the leap to private practice, or even if you decide it's not for you and you're going to stay in a hospital, just, if you haven't got a will, make sure you think about getting one, because even if you're just working in a hospital already, you'll have substantial money probably in super. You may have insurance policies. And if you get wills done properly, they can become far more tax effective with things like testamentary trusts and things. So it really is important that, you know, you've spent all this time training and learning and working, that you do then, I guess, protect those assets for your family if something does happen to you. And look, if anyone has questions about that, I would encourage you to just shoot me an email. I'm not an estate planning lawyer, but it is just such an important piece, because we have seen circumstances where people just don't think about this and then they have really bad outcomes. So we basically talk about that in everything we do, just at the end, because it's really critical. Just with all of this stuff, just ask questions early. Generally, I know Ben is very generous with his time. If you have something that's keeping you up at night and you're not sure about it, just give us a call. Generally, sometimes you don't even have a problem and you just get that peace of mind immediately. But usually the earlier you do it, the better the fix is and the cheaper the fix is. So just get out in front of things, and ask questions early and often, I suppose. And that is all I have. I'll just put this up. Just, there's QR codes for both of us. Now, there is also, I'm not sure if everyone here is from RACS, but I know there is a RACS event that I'll be appearing at on the weekend, the Foundations of Private Practice, which will be similar to a lot of the things we've talked about tonight, but it is going to be obviously a bit more in depth because it's across 2 days instead of the half hour here that Ben and I have whipped through all this stuff. So yeah, look, if you do have the time and the inclination, feel free to look into that. And probably if you scan one of those QR codes or shoot either of us an email, we'll be able to point you in the right direction as well.
Yeah, absolutely.
Now, I think, Ben, can you see? I think there might have been a question, which was a very accounting specific question.
Lucky me.
Yeah.
There was one question from an anonymous attendee. Do you still need to register for GST and provide business activity statements? if the private practice is mostly working as a surgical assistant. So if you are working as a surgical assistant and you are being paid via an ABN rather than salary and wages, which would be 90 to 95% of surgical assistants, and you envisage that you will turn over more than 12 months, $75,000 in 12 months, you still need to register for GST and prepare and lodge quarterly business activity statements. If it's less than $75,000 in turnover, you do not need to be registered for GST.
Awesome.
Perfect. All right. There are no other questions, so we'll leave it there. But thank you everyone for joining us, and again for Rax and the great relationship that we have.
Thanks, everyone.